Hello and welcome everyone. By 2025, it's estimated that the world will generate over 463 exabytes of data daily, which means every click, every swipe, and every scroll of yours is creating data. Now multiply that by billions of people every single day. While I let you all sit with that for a moment, a heartily welcome, good evening to one and all our esteemed speakers and attendees. It's an absolute pleasure to have you all here today as we explore one of the most crucial and rapidly evolving topics of the digital world: data ownership in the age of artificial intelligence. The world is experiencing a paradigm shift as AI continues to reshape industries, societies, and individual lives. We find ourselves at a crossroad, one that forces us to rethink how we collect, use, and most importantly, who owns the data that fuels these intelligent systems. Data has become the new oil, powering everything from personalized recommendations to predictive healthcare. But this powerful resource also comes with profound legal, ethical, and societal implications. So today we ask, who truly owns the data we generate? How can individuals retain control over their personal information as an AI driven world? And what legal mechanisms are needed to ensure that innovation doesn't come at the cost of autonomy, privacy, and fairness? These will be the questions that we will be diving in today in our exciting webinar titled Navigating the Future of Data Ownership: Legal Challenges and Opportunities in the Age of AI, organized by Wiplo. Wiplo, a law firm at the cutting edge of legal innovation, specializing in emerging sectors like AI, blockchain, and of course, data privacy. With a track record of delivering impactful legal advice and contributing to global policy frameworks, Wiplo continues to define the future of legal and financial ecosystems worldwide. To all our attendees today, thank you for joining us today. Your interest and active participation are what truly makes this conversation dynamic and impactful. We encourage you to ask questions, share your insights, and be part of this critical dialogue on the future of data ownership. Also, a quick note: certificates of attendees will be available to all the participants who stay for at least 50 minutes, and these will remain available until April 18th, 2025. So make sure to claim yours. We'd also like to extend our gratitude to our supporting partners, WICCI Karnataka Technology Empowerment Council and WICCI National Council for Artificial Intelligence, for their efforts in driving inclusive innovation and shaping progressive tech policy. We would also like to extend our gratitude to SIGNET One, a leader in digital transformation, enabling innovation through advanced engineering, and also to Indian Technology News, a news platform that simplifies complex tech trends and impart knowledge. Their support has been vital in making this webinar a reality. Now, today, we have a brilliant panel of speakers lined up. First is Mr. Swar Kansagra, co-founder of Wiplo, with deep expertise in global data regulation, AI policy framework, and cross-border compliance. His unique ability to bridge technology and legal systems make him an essential voice in navigating the complex landscape of AI governance. Today, he will shed light on data ownership, privacy, and evolving legal challenges around AI under global regulation, including DPDP and GDPR. Our second speaker is Mr. Parth Chhatrala, an accomplished in-house counsel specializing in AI and data compliance. With a strong track record of aligning legal strategies with engineering and product innovation, he ensures that AI advancements remain compliant and responsible. His insights are key to understanding how companies can navigate the legal risk of AI innovation and liability management. His perspective today will offer a practical roadmap for embedding compliance into AI driven business models. Our third speaker is Mr. Akshay Dodhiwala, founder, innovator, and chief data scientist with over a decade of experience in implementing AI and building AI enabled products. Renowned for his ability to drive digital transformation, Mr. Akshay bridges the gap between cutting edge technology and real world business needs. He'll provide a critical perspective on how companies can balance innovation and data ownership while still monetizing and scaling responsibly. As we step into the heart of today's session, we'll explore the evolving landscape and ethical contours of data ownership in the age of AI. Together, we'll examine how AI systems are built using vast amounts of data and the rising complexities around it, and how legal experts and compliance leaders are working to strike a balance, ensuring the technological innovations moves forward, but not at the cost of privacy and accountability. Most importantly, we'll ask, how do we design a future where compliance isn't just a checklist, but a foundation for trust, scale, and responsible AI adoption? We highly encourage all of you to take part during the Q&A session. Please don't hold back and drop your questions, reflection, and perspectives in the Q&A box. Let's co-create this conversation. So without further delay, I'm delighted to invite Mr. Swar Kansagra to open the session with his insights into the legal challenges and opportunities around data ownership in the AI era. Mr. Swar, the virtual stage is all yours.
Thank you, Leah. I hope I'm audible.
Yes, you're audible, sir.
Okay. Thank you all. Thank you for stepping out of your comfort zone today. Saturday evening is something which is a very comfortable time for all of you, and you all are managing from that comfortable time and you are being part of this webinar. We're thankful for that. And of course, we see lots of participation who of course wants to be part of AI ecosystem. So without further delay, let's start. Can we have the presentation? Leah, can we have the presentation?
Yes, sir. We're working on it.
This is the challenges that we face when it comes to tech solutions. Of course, COVID has taught us a lot of things, virtually joining with people, but sometimes like the instant time, we sometimes even find it difficult to connect. So these are some of the technological challenges that we need to overcome. But sooner or later, I think AI will overcome everything and will be part of technology. And I'm thankful for all of you to be here. I'm also thankful to all the speakers. Thank you. I think it's visible to attendees as well. So thank you to our supporters as well, who has been prompt enough to support our initiatives, the knowledge platforms that we share with the audience. You probably heard the phrase data. Data is the new oil, but unlike oil, ownership and rights are not clear. Unlike oil, data doesn't have universally agreed upon ownership rights. At least that's what the present situation is. So who owns the data? The person it's about, the platform that collected it, the company that trained a model on it. So who really owns it? The answer are unclear. And that's why legal strategies in this space is not just a good idea, it's a critical thing. Let's explore how the law is evolving to meet these challenges. We are seeing an explosion of AI tools like ChatGPT and their use in deeply integrated into business processes. But with that comes a new legal questions. Who owns the output? Who is responsible if things go wrong? Think of this as your legal roadmap for the AI-driven company or AI-driven economy. Let's understand the data ownership, why it matters now. Let's start with a simple question. What is data ownership? At its core, data ownership refers to the legal or the contractual rights that determine who can control, use, share, monetize, and delete data. Now, unlike physical assets, where ownership is clearly defined, data does not have a universal ownership law. Instead, it's typically governed by a combination of contracts and agreements between the parties, intellectual property laws, and privacy and data protection regulations like GDPR and CCPA. So essentially, data ownership is more about legal frameworks and context rather than a one size fits for all rule. So why is this important now? Now, why is data ownership such a hot topic today? Some of the few key reasons. First, we have seen an explosion in AI tools. So ChatGPT and now even Sora from OpenAI. These tools are generating and relying on massive amounts of data. Second is AI is no longer limited to tech companies. It is becoming deeply embedded in industries like manufacturing, supply chain, and quality control, where proprietary data is critical. Third, we are in an era of tightening regulatory scrutiny. For example, in May 2023, Meta was fined a record of 1.2 billion euro by the Irish DPC for violating GDPR by transferring EU user data to the US without proper safeguards, a major warning to the companies about the cost of non-compliance, which means 78% of organizations now use AI in at least one of the functions that they produce. And there's a surge in IP related legal battles. We are all heard of cases like New York Times suing OpenAI or Getty Images taking stability AI to court, where the New York Times sued OpenAI and Microsoft, claiming their articles were used without permission to train ChatGPT, amounting to copyright infringement. These companies argue the use of qualifies as fair use. Getty sued Stability AI for alleging using millions of its copyrighted images without permission to train Stable Diffusion, claiming violation of copyright and database rights. All of this puts data ownership in front center, make it as a key issue for both legal and operational strategies moving forward. Coming to the very basic questions, who owns the data? Unlike physical property, data ownership isn't defined by a single global law. Instead, it's shaped by a combination of legal frameworks and various based on context. There are three key legal tools that typically come into play. The first, contracts. These are the most dependable way to define and assign data rights. Contracts determine who can access, use, share, or monetize data, and they are enforceable under law. Second, intellectual property or the IP laws. The IP law protects the way data is organized, processed, and presented like a structured databases. But it does not cover raw data on its own. The third is privacy and data protection laws such as GDPR or India's DPDP Act. This gives individuals significant control over their personal data, for example, through right to access, delete, or restrict it. However, they do not grant ownership in traditional sense. Now, here's the real challenge. There's still no universal legal definition of data ownership, and among which 74% of companies are unclear about who owns AI processed data. 70 to 85% of generative AI models lack proper data origin tracking. AI usage in Indian enterprises rose 40% from past 2 years, but only 23% have legal frameworks for data. These figures are alarming. In many cases, data rights depend heavily on the context, the agreement in place, and the jurisdiction involved. And with AI and digital systems, data often passes through multiple entities, that is collectors who collect the data, processors who processes the data, platform providers, and the end users, each with their own claims or rights. This makes the concept of ownership even more complex and layered. What now? What laws matter and how are they changing? That's something which each and every company is trying to find out today. So as AI continues to advance rapidly, global regulators are racing to catch up, creating a patchwork of laws and frameworks that organizations must navigate carefully. Let's walk through the key legal developments shaping data use and AI governance today. The first is EU AI Act, adopted on 13th March 2024. This is world's first comprehensive AI law. It places strict obligations on so-called high-risk AI systems, including mandatory data governance audits. For generative AI providers, like those building large language model, it now requires transparency about the origin of training data, a major step towards responsible AI use. The second is US AI Bill of Rights, currently a non-binding framework, but a step forward for with respect to the AI regulations by US. While not enforceable law, it's shaping best practices around transparency, data protection, and bias prevention. Many US companies are aligning voluntarily to mitigate future legal risks. India's DPDP Act is the third example. A significant development in Asia, this act introduces cross-border data transfer restrictions and strengthens purpose limitation, meaning data must only be used for the reason it was collected. Now we have India's draft DPDP rules 2025, released in January 2025. This rules outline how DPDP Act will be implemented. Some of the key highlights which include clear notice and consent requirements for data collection, parental consent mandatory for processing children's data, mandatory deletion of user data after 3 years of inactivity, of course, for large platforms, annual data protection impact assessments for significant data fiduciaries, prompt data breach notification to users and the data protection board, a fully digital data protection board for grievance redressal. These are some of the key reforms that the rules is going to implement. And it's not just four. According to UNESCO's Global AI Tracker, as of 2025, over 50 countries are now in the process of drafting AI policy. This shows that AI and data regulations are no longer optional or abstract. They are rapidly evolving with growing global convergence around transparency, data protection, and accountability. This being said, let's understand what are the risks involved in data ownership. As we explore AI data ownership, it's important to understand that legal risk is not just theoretical, it's happening in real time across industries. Let's walk through the legal risk matrix with a few concrete examples that highlight why this matters. Unlicensed training data. When companies use publicity, available or scrapped content without proper rights, they risk violating intellectual property laws. A good example is Sarah Silverman versus Mehta and OpenAI. She, sorry, it's Meta and OpenAI. She and other authors sued for unauthorized use of their books in AI training datasets. This shows that even non-visual content like literature or code isn't safe from IP disputes. The second is lack of audit trails. A lack of transparency in how data flows through AI systems can lead to compliance issues. In 2023, Clearview AI, a facial recognition company, faced regulatory penalties across Europe because it failed to provide users with access logs or show how their images were used. The absence of Audit trails made it nearly impossible for regulators to verify lawful processing. Then comes undefined data ownership in contracts. This is very much important because any of the transaction, of course, starts with contracts. So when ownership or licensing terms aren't clearly written into contracts, disputes quickly follow. Take the case of Zoom's AI Terms Update 2023. After users' backlash and regulatory scrutiny over unclear language about using consumer data to train AI, Zoom had to revise its terms. This situation underlined the importance of explicit consent and contractual clarity, not just with partners, but with users as well. And there comes the well-known definition or well-known theory of black box with no traceability. AI systems that can't explain their outputs are particularly vulnerable in regulated sectors. A recent case involved a healthcare AI system used to predict patent risks. When challenged in court after a misdiagnosis, the company couldn't explain how the AI reached its decision. This sparked concern about medical liability and the lack of traceability, issues that could escalate under health regulations. Each of these cases reinforces the growing expectation that companies must treat AI not just as a technical tool, but as a regulated ecosystem. Legal readiness through licensing, auditability, clear contracts, and transparency will be the key to scaling AI responsibly. All this being said, let's understand what are the strategies that organizations or the individuals should follow. And organizations increasingly rely on AI systems. Safeguarding data rights is becoming a core legal and operational priority. This slide focuses on practical legal strategies to ensure that your organization maintains clear ownership and control over its data assets. First, the core legal approaches. The first, organization lies in well-drafted contracts. Define who owns the data, how it can be used, shared, and retained, especially in agreements with AI vendors, SaaS providers, or data processors. Second, use strong confidentiality measures such as NDAs, secure data transfers, and periodic vendor audits to prevent misuse of or leakage of proprietary data. And finally, require that your AI vendors disclose the data practices. This is very much important. Otherwise, you will not be able to know how your vendors are processing the data. You want transparency around where their training data comes from, how your data is being handled, and whether it's used to train other models or not. Now let's look at a few practical steps you can take. Include clear ownership clauses in AI and vendor contracts. This protects against future disputes. Second is encrypt and classify your data sets based on risk and sensitivity. This helps control access and supports compliance. The third is consider using smart contracts, especially in blockchain or decentralized environments to enforce data use terms automatically. Run regular audits and conduct data protection impact assessment, especially when using generative AI tools that process personal and sensitive data. Let's focus on some of the examples which follows this. SAP, Systems, Applications and Product and Data Processings, now require its generative AI vendors to tag the origin of training data during vendor reviews. IBM Watson includes strict ownership enforcement in its API terms, ensuring client data remains protected. And several European banks now mandate DPIAs and encrypted data contracts when working with AI vendors handling customer data. Taken together, these legal strategies don't just mitigate risk, they help build a foundation of trust, accountability, and long-term AI readiness. So what are the future of compliance? As we look ahead, the regulatory landscape is only going to become more complex and demanding. Organizations need to evolve from reactive compliance measures to proactive, risk-based, and culturally embedded frameworks. This slide highlights the 10 key pillars that will define effective compliance program over the next decades. Starting from the left, risk assessment and monitoring. This is the cornerstone. Continuous data-driven risk assessment will allow us to anticipate issues before they escalate. Policy management. Policies must not just exist, but be living documents consistently updated to reflect new risk and communicated clearly across all levels. Then comes the third party management. As companies rely more on external partners, managing risks from third party vendors and suppliers and contractors become critical. Program improvement, testing, and review. Compliance isn't static. Regular testing and program assessment ensures effectiveness and responsiveness to change. Analysis and remediation of underlying misconduct. Instead of training symptoms, Instead of treating symptoms, future compliance will focus on identifying root causes and fixing systematic issues. Moving to the second part, speak up culture and the reporting structure. Encouraging openness and psychological safety empowers employees to report unethical conduct without fear. Training and communications. Engaging targeted training tailored by roles will replace outdated check the box training. Compliance staff and licensing. We will see a rise in strategically placed compliance ambassadors who bridge the gap between business units and the compliance teams. Investigations of misconduct. Robust, transparent investigation protocols will be essential to maintaining trust and organizational integrity. And then comes the compensation structures and consequence management. Performance incentives must be aligned with compliance goals, and misconducts must be addressed fairly and consistently. At the center of all this is a shift in the mindset from tick the box compliance to building a resilient ethical culture. The framework is not just a roadmap for compliance professionals, it's a blueprint for sustainable business conduct in 2030 and beyond. Let's begin by looking at the role of AI plays in cybersecurity. With AI-driven security tools, business can significantly enhance their defense mechanism. AI-based cybersecurity can reduce breach detection time by 90%, providing real-time threat detection and auto mitigation. Adopt AI cybersecurity systems. Mahindra and Mahindra provides an excellent example, having integrated both AI and blockchain for secure supply chain data management, which has been key in mitigating cyber threats. Now let's talk about the legal framework surrounding AI and data privacy in India. A major development in DPDP Act, which mandates data protection and impact assessment for AI system. This means companies need to assess and mitigate risk before deploying data. For business operating internationally, aligning the global framework is equally important. Compliance with laws like GDPR and EU AI Act ensures smooth cross-border data sharing. Industry adoption of AI and real-world challenges. Let's take a closer look on how industries are currently adopting AI and, more importantly, the real-world challenges that they are emerging from this adoption. TCS has implemented internal AI audit systems to track and trace data lineage in enterprise application. Infosys, after the introduction of Infosys updated its vendor contracts to explicitly define data usage rights, ensuring clarity in AI-driven projects. The NHS partnered with DeepMind to develop AI diagnostics tools, but faced backlash due to lack of transparency regarding how patient data was used for AI training. This all being said, I will wrap up quickly as I'm quickly running out of time. Define ownership of data, strict data protection law and compliance, manage AI models. AI trained on biased or flawed data can produce inaccurate, so take care about that. Public concerns over AI role is surveillance, consent, and misinformation, which can damage your brand. And at the end, conclusion, As AI becomes more integrated into business operation, it's crucial to balance privacy, security, and legal governance. Understanding that complying with the regulatory landscape, especially with the laws like GDPR Act, it is for safeguarding both data and business operations. Data ownership, legal centrality, guide for AI journey with a clear privacy, IP, and compliance laws, using AI security tools, blockchain and encryption to protect data. Sustainability and data monetization offers great opportunity only with right contracts and compliance. As we move to the panel, I would want to leave you with this clarity. Clarity around data isn't just about avoiding lawsuits, it's a competitive advantage. The companies who get the right will move faster, innovate safely, and build trust. In the age of AI, data isn't just an asset, it's a liability unless owned, protected, and governed with legal sight. Thank you for hearing me. I'm open to questions at the end.
Thank you so much, Mr. Swar, for an eye-opening session. Now it's my pleasure to welcome Mr. Parth Chhatrala to the stage. We are eager to hear your thoughts, sir. Over to you.
Hi, good evening, everyone. Uh, I hope I'm loud and clear and my voice is audible.
Yes, you're audible, sir.
Nice, thanks. First of all, I would like to give a huge vote of thanks to Vithula and Swar to take this topic up. It's high time to discuss AI and legal challenges and its regulatory role. Thank you so much. I feel honored as a part of legal team of Signet to speak up on this topic. Next, I would just give a brief intro of mine. I am Deputy Manager Legal at Signet Infotech, Signet Group. And apart from this, I am also an in-house legal counsel and an official AI auditor, AI internal auditor, uh, who certifies his company's compliance with ISO 42001. And yeah, so my basically my role is to ensure legal compliance and litigation and non-litigation everything, including AI, right? Uh, while I would I let me just give a quick glance through what I would be speaking at today. I have divided my presentation into three parts, which would be which would be first, like, as a role of what would be the role of in-house counsel, right? What would be my role, or anyone who is an in-house counsel who would be working in a company, what would his role exactly be like with respect to compliance, with respect to AI, and whatever it may be. It may be contracts or it may be in all litigation, but into AI, only this perspective. And I would be also throwing some light on the challenges. And lastly, I would be concluding by giving my suggestions to the Indian government with respect to AI and its regulations, which we feel what based on whatever challenges we are facing as a IT company in India, right, with respect to AI. So with this, I would like to start my presentation. I would just request Leah or Saloni to share my presentation.
Yes, sir. We'll be sharing that in a few
Yeah,
seconds.
yeah.
Again, tech issues.
Yeah, it's so common, I guess. Or I have my presentation ready. If it's possible, I can also share my screen.
Yes, sir. You can go ahead with that in that case.
Yeah, just give me a moment. Okay, so I hope my screen is visible now.
Yes, it's visible.
Yeah, great. Okay, just a second. Okay, so first of all, starting with my role as an in-house counsel at Signet One. its first thing is to manage risk and compliances across all departments. So when we speak about AI, right? Obviously, as Swar led us through the regulatory compliances India, whether it may be DPDPA Act where data comes into force, whether it be GDPR, because even though GDPR is a European law, it does apply to companies in India, right? Because whoever is doing any sort of business with any European country, GDPR is becomes applicable. So all those compliances, whatever in place, it may be guidelines by Ministry of Information and Technology, it may be NITI Aayog's rule book for AI, right? We ensure its compliance. It may be ISO certified. Like we are not ISO certified for AI as of now, but for example, if any company is, the role would be to ensure that we have all those standards complied with regarding to AI. So I have to act as a bridge between all those departments. For security purposes, I have to be in touch with our CISO, which is Chief Information Security Officer. I have to be in touch with our IT support team who ensures connectivity at all time, who ensures that there are no, leakage of data. As Swar said, that it is a very important to maintain data at one place, not allow it to flow out of the organization, to ensure our admin team who takes care of our data center, right? Who ensures that data center is true in true sense be prevented from any entry of or from any external access. So I have to manage all those departments. I have to ensure that there are proper contracts in place. There are proper agreements with vendors to ensure security. There are proper firewalls we purchase. We have to ensure. I have to coordinate with our purchase teams who purchases licenses time to time related to firewall, related to antiviruses and security, all that, right? So we have to act as a bridge, because ultimately at the end of the day, all these things may seem a non-legal part, but they are legal because in a way it ensures compliance. It falls under the bracket of compliance department, right? Secondly, uh, recently ISO had came up with ISO 42001. You all would be very surprised to know that ISO 42001 related to artificial intelligence, very few companies, a very handful of them, I believe only 3 or 4 companies in India are ISO certified for AI. Great. So this leaves a huge room in India to implement ISO certification for AI. So even Signet, I can disclose in this forum, even Signet is considering to be an ISO certified company. For AI, we already have ISO certification for information management systems, right? Which is, I guess, 27001. This is 42001 for AI. So if we want to implement that, I have to again act as a bridge and ensure each and every norms of ISO certification are followed. It briefly involves maintaining policies, maintaining documentation, maintaining controls, ensuring controls, having audit from time to time, and all those things, right? Now, given these compliances, our real challenge is our real area of work would be maintaining a balance between speed and compliance, right? So it's not that if we implement ISO 42001 for AI and security, we have huge amount of time. No, we don't have time. Like in the cutting edge of AI, as Swar said, people are just fighting to be an AI first company, right? And it's really very challenging to ensure speed and compliance together. So if we want to be an AI first company, we also have to take compliance hand in hand, and for that we have to tie up with the vendors. For that we have to, because compliance comes with a cost, right? It's not just that you have a compliance team and who will just take care of this and it will happen all of a sudden one fine day. No, it doesn't happen like that. We have to devote time and efforts for this. We have to I will just take one example, right? In ISO 42001, there is a requirement of fire extinguisher in the data center systems where the data is stored, where the again LLM is implemented, right? So I have to ensure that there are proper checks in place. I have to uh, appoint the vendors. To appoint vendors, again, I have to do a very background verification check. Again, I have to appoint some employee who takes care of the compliances, who sees that the oxygen tanks are filled. There are proper control fire extinguishers are implemented. Again, those fire extinguisher, it goes, you won't believe, it goes into so much detail. even the nozzle of the fire extinguisher is being checked by the internal auditors to see that it is not corroded. Because if it is corroded, right, it would not be able to spring the water properly, and again it would be non-compliance. So just imagine a small rust in the nozzle of one of the fire extinguisher in one corner of our room will lead to a non-compliance, triggering a huge chain of events, right? So this comes with a cost. We have to check each and every compliances one by one. So now again we have to maintain the balance between speed and compliance. And the third pillar is the cost. So now again, we are successful in maintaining the speed, the compliance, then again, cost is the issue. Because if we appoint too many teams to work on this, too many vendors to work on this, to coordinate the time, the efforts, we may have to forego a cost impact because not all the vendors would be available at the same time, right? So if we want to make that happen, we might have to increase our cost and select a vendor who is available, even if it has more cost impact on us. Right. So this is the main challenge in as an in-house counsel to because ultimately again, see, maintaining cost might not be directly related to legal team, but again, because it is related to compliance, these are the subcategories that we have to take care into, right? And lastly, innovation with legal tech, right? We have to focus on the innovation aspect as well. Whatever our product and engineering team are working on, we have to cross check that they are not following, I mean, they are not in non-compliance with any of the legal norms. For example, if any product engineering team is working on a AI based offering and they have integrated any sort of third party using AI, right? We have to go through each and every clause of the terms of use of the privacy policy and of the EULA, the end user license agreement of such third party. It may be Perplexity AI, it may be OpenAI, it may be any third party who is, it may be Gemini, it may be anything. And we have to read all those each and every documents in detail. So this is all in all the role of an in-house counsel, just as a with respect to maintaining compliances for AI. This is just for AI, right? My perspective is limited to management of artificial intelligence in Signet and in any and what would be a role of any a legal person with respect to AI. So now with this, I would be moving forward with the legal challenges that I believe that all the people in this field, including myself, is facing with respect to AI in in-house counsel as an in-house counsel, right? Now, first of all, the biggest risk is there is no regulation, right? There is no regulation, especially for AI. For data, even the draft rules are formed, which are not implemented as of now, and let alone the artificial intelligence. The UK was the first one to come up with a proper definition of AI and detailed law on this. But I hope you imagine that where any sector is not regulated, which any company is working on, right? Today we are working on some sort of AI projects. Any X party or any third party is working on it. Whosoever wants to capture opportunities in the field of AI, just imagine a situation where that today or tomorrow, your work, your tasks, your assignments, your clients, everything, your industry would be definitely be regulated in some or the other way, right? There is no other second thought or no doubt, there is no iota of doubt that your sector is going to be spared with this. It is going to be regulated at some point of time, if not now, then in future. But just imagine a situation where I am developing a product. I don't know that which piece of regulation I would have to follow in future. If today I make investments in it, if today I devote efforts, I devote financial, I take loans, I in case of startups, if any startups wants to develop AI product, it raises money, it raises equity, it calls in investors, everything is at stake. And tomorrow, one fine day, any piece of regulation can come up which can negatively impact its work. For example, if any and startup is working on a area which today, because there is no regulation, it is allowed. But tomorrow, if government comes up with a regulation banning some sort of AI in that sector, for example, defense, or for example, dark web, or for example, genetical engineering. Now you just imagine how much scope there is of AI in genetical engineering to engineer some sort of genes for the, of course, for the betterment of society. But as we speak, genetical engineering is some subject in India which is very restricted. So now if I want to develop a product, but tomorrow if government come up with regulation which does not allow the use of AI in this field, my everything would be gone, zero, right? So that is the biggest risk. All the huge that there would be huge investments in dark zones. What about the equity that I have raised? What about the capital that I have raised? What about my loans if I taken debt? What about those? How will I repay it? Right, my entire dependence is on that. I would be literally bankrupt. So this is the huge challenge. So if today anybody wants to start a work in the field of AI, the new players cannot do it because of these risk. It would be only the existing players who can afford their investments to go zero because they have other work to do, because their businesses are running. Infosys can take risk to let their investment zero, or to bear that loss, but new company cannot. So this is the biggest challenge. Recently, I will give you one example. Ministry of Information and Technology, they had come up with a notification which required that any investments in the fields of AI would have to be first approved by ministry. Right. The moment they came up with this notification, there was huge negative impact. People were just terrified. The industry players objected it, and after so much of objections from all the industry players, finally ministry had to roll back that notification and do away with that the requirement. So you can imagine that how much impact does the regulations have on this, right? There is one more example, the principles of responsible AI. In short, it was known as AI for all. Was published by Niti Aayog, right? Those were some kind of relaxed, I would say, in compared to the requirement of having it registered. Like we have to follow that. Now again, these are guidelines, and these are just principles, right? What about if there is any change in the principle? So now if the principles have changed, because we don't know what kind of principles even government wants to implement. Now, if any product is developed today based on those principles, if I, as a legal person, guide my development team to follow those laws, those principles, those doctrines which government has given us, if tomorrow more strict versions come up, of course there is scope to change it, to change the product, but that again would be attracting more time and efforts and money to make it compliant with the new ones, right? And lastly, all the government APIs are closed, right? I would give you example of IP India, or I would give you example of eCourts, right? eCourts is a website which I'm not sure is if it is of government or if it is outsourced to a private company, but it is related to judiciary where all the cases dates are shown. If I have a case against me going on in eCourts, right, then I can track my case. So now just imagine there are lakhs and lakhs of cases going on. Now there is so much of scope of AI in developing this solution which can help litigation management, right? Which can give insights in litigation management, which can really help problem of judges to solve. There is a huge burden on Indian judiciary. It is to the extent that I think it was a manifesto in one of our the local politics that there are so much of cases government should do about something about it, right? Now AI has this potential to do something about it, but the APIs are closed today. We cannot fetch details without permission from government, and it would be web scraping, right? Web scraping is illegal in India. We cannot just do from backend. We can pull out data and work on it and then come up with a solution. Similarly, in case of trademarks, the trademark registry has so much of data. It today it is accessible to individuals, but that access is, we have to give OTP. We have to we have to ensure that we are not doing data mining illegally. We are not doing web scraping, right? So now just imagine if these APIs are open officially. I'm not saying unofficially. If the government officially gives us chance to have the access, then we can develop we can develop some LLM. We can develop a product around it. We can work and we can train the AI product, and we can train the AI product with the help of these data from the data of trademarks in case of IP India, from the data of courts, litigations, in case of e-courts, railways, MCA, government websites, they all can be a huge role in play in case of training of training of AI solutions, right? This is not happening right now. Well, government has to come up with it has to relax some sort of norms, but it's not that. So again, it is a big challenge. This is acting as a hindrance in development. So all in all, this is the challenges that we are facing. Uh, Again, some sort of examples I would like to quote, right? The next challenge is very low reliability, right? In OpenAI, which is ChatGPT, they are literally disclaiming that their outputs are not verified, that their outputs are not may not be relevant, their outputs may not be true. We have to verify it externally, and we cannot just blindly rely on it. This is their AI terms and conditions. I have read the entire legal terms and conditions of this ChatGPT. Literally, they are not saying that they are as if like, see, we are not liable for any kind of output. It's at your own risk. Now, how can we rely on this AI, right? So if we are as an in-house counsel of a company, IT company, I cannot tell my product team to work to take help of ChatGPT, because I know as a legal person that they are disclaiming the output and its correctness. In fact, I would say that Google is better than this. Google, which is a yesterday's technology, is better than ChatGPT because at least it shows the source of the information. ChatGPT does not disclose the source, with an exception that Perplexity AI, which is again a chatbot, does show the source of the information, which makes it a little better than ChatGPT. And in fact, that is why Perplexity AI has received huge funding, because it is more reliable, because it is showing source. This is a small exception, right? Again, next example is, what are the legal remedies available to us, right? Uh, Tomorrow, if I rely on some sort of output from ChatGPT to make my work more productive, they like I have to go and file a case in San Francisco, because their terms of use, their legal agreement literally says that whatever disputes you have to come to US in California and file a case there. You don't have any jurisdiction in your local country. This is what they have disclaimed, which is literally impractical. Tomorrow I rely on ChatGPT and make some products, or make me myself productive. And if some, God forbid, something happens, I may have to rush to ChatGPT, or even worse, they may call me over there in California. And lastly, I have few suggestions to make to government, uh, Indian government specifically, so that this AI in India can really be a growth engine for India at a large scale, right? First of all, an AI Act. This will enable developers like us, legal persons like us, who can be a bridge between explaining law in simpler language to the product engineering teams. If the AI is defined properly, I myself can understand it, its understanding its implication, and guide my internal team, and guide my product engineering team in my company in Signet One, and say that, okay, so this is the definition of an AI, and if you're developing this product, be mindful of these many regulations XYZ. Right. So now we know the path. We know that we have to move in this direction. Right. So if AI Act is there, we would be having a clear roadmap how to proceed. And next is AI codes. Now, please come up with an AI code where we know that if something goes down the line, which authority to approach. Today, there is no authority, except there may be few authorities like, civil courts. If someone feels that my IP is breached, you can approach civil, but that is very vague. Like, there is no official designated code for AI. It may be integrated with existing codes like IP codes, but that official integration should be there in law, right? And some sort of speedy approval mechanism for ongoing projects. Like I said, there are many projects ongoing in Signet also, and outside of Signet, there are other companies also who are working on AI. If in case it has to be regulated, the approval should be very speedy with some sort of time limit defined in the act. And lastly, very relaxed norms for data mining. As I said, government has to loose down on data mining norms. If I want to make my model and I want to come up with solutions which are having practical problems right now in many fields, then government has to lose its stand on its AI. I mean, its information as stored in, as we discussed about example of e-courts and MCA, Ministry of Corporate Affairs, and IP India, who have thousands of GBs of data, which if it is open, to not to literally open to public, but with permission, with approvals, it has given rights to some companies. They can come up with better solution, better case management, easy solution of disputes, and ultimately the political parties can also benefit from it if they can say openly that okay, now we would try to reduce the burden of judiciary and make disputes solved very easily, right? This would happen if they release their stands on AI. They make it liberal. We use the data, we come up with IT software solutions who can ultimately reduce the burden of courts, and ultimately the justice would happen in a speedy manner. So to do that, they have to relax the norms. So these are the suggestions by a person who is very actively, I call myself very active in the field of AI. And I would be the happiest person if this gets implemented, and really I would be looking forward to it. Yeah, so with this, I would like to hand over my presentation. I would be open to questions at the end of the session.
Thank you, Mr. Parth. Your insights made the path forward in the AI era feel more clear and actionable. Now
Thanks.
we move on with Mr. Akshay Dodhiwala. Look forward for your perspectives and insights, Mr. Akshay. Over to you.
Thank you so much. Hello team, how are you? So yes, basically I'm a founder. I do. I am a data scientist with almost a decade of experience. I am a founder. I hold a place in multiple companies. Today, I'm very thankful to Witla to bring me here and discuss AI. My peers, Parth and Swar, have already talked on how they think the current market for AI is in terms of legal, what is missing, and how we can enhance it further. And I'm glad that I got to hear from Parth and Swar onto this. And now I'll take up the lead. My topics will encompass few things in terms of technical implementation. We came to know what is the current state. We came to know what can be done, what is missing in terms of legal framework. Now, I talk on two aspects. One is what responsible AI is and how we can implement at a granular level. So to navigate current legal market space and current data ownership. So let's start. Few people might have heard of responsible AI, and Shwar and Parth both have talked on it, have stated that we should follow responsible AI practices, and Niti Aayog has this policy as well. I would say GPAI, a central body under UN's observation, has already started working on implementation of responsible AI practices. But what is responsible AI? A practice where we follow ethical ways of utilizing AI's capabilities called responsible AI. We might have known that while back DeepSeek came into market, initial days it was able to pitch out unethical codes. If you have asked AI that spit out a script where I can do hacking for this particular website, then it was able to do that. But later, after 2 3 days, once everyone started talking on this, they reverted the change. They also had considered Arunachal Pradesh, a region of Arunachal Pradesh, as Chinese territory. But later they reverted back it to that they are not able to comment on this being a political issue. So this came after a few people highlighted it, and many companies and many countries boycotted DeepSeek, and that's when they started looking forward to that. But what if they had implemented this practice a long time back and they had implemented restrictions, they had implemented content filters, they might have utilized few unethical sources for data, but what if they used an ethical source to gather their information? If that would have happened, then they might not have faced the backlash they currently face. Many countries in Europe are thinking of banning it, and few countries, namely Italy, Germany, have already banned usage of DeepSeek due to being a Chinese model and due to some political issues. And that's the reason AI practices at global level needs a standard framework, a standard legal framework for incorporating data as well as incorporating ethical usage of data. See, data cannot be bias free in its natural form. Human, as a human, I might be biased to some norms, some nomenclatures, or some situations in the world. Few people might like animal cruelty because they eat non-veg and they are okay with that, but few people are not. It's an ethical standpoint. And ethics are based on perspective. And as such, it depends on person to person. Few might think that having certain criteria implemented at a general level on individual basis or at a company level for AI as a good practice. But no, having a framework at a global level so that everyone is aware of it is what we need right now. And that's what responsible AI and GPAI are doing. They are looking forward to it. So the question comes, responsible AI is there, ethical practices is there, how we can implement it, or how we as product owners have faced the scenario. Earlier, back in days, while I was preparing a product on renewable energy sources, I have a product on renewable energy along with AI, which does certain kind of prediction. Back then, gathering data, I'm talking about 2018 and 2019. Back then, gathering data was very hard because in rural areas, internet connectivity was not at a scale. We didn't we didn't have that global connectivity. We didn't had 5G back then. 4G was utilized. Not many towers were there. So what we did is we paid a vendor who had a person there sitting gathering data for a huge, I would say, 500 megawatt plant, gathering data on day-to-day basis for 2 months, and that's when we had enough and sufficient data because of cheap labor and because of unethical practices. That person had to be there for roughly 12 to 15 hours daily, and he used to collect data for us. And that's how we started building our model. After that, after that scenario, what we thought of that instead of implementing a person or instead of employing a person to do this and exploiting the labor, we started to focus on few other things. We purchased an hardware, we went there, implemented the hardware, and then started gathering all the crucial pieces of information which we wanted. So that's data gathering limitation. First, gathering data ethically is the first and foremost rule. There's no privacy laws within India, and as such, we see that many a times we get phone calls from multiple people who wants to sell their products, who wants to sell their ideas to us and pitch credit cards to be precise. From where they do gather this data? It comes from all the lucky draws which we have filled, all the forms which we unintentionally have shared. It comes from all the applications which we have installed and they have asked us to send their message and asked us to give permission to receive call or receive message. So this application, they gather our information and they share it. It is available in all the markets out there. I can get anyone's phone number and I can start calling. Because in India, there are no privacy laws. They are coming up with it, and that's when data privacy laws will be there in place. responsible AI framework will be in place. And from there, we will have a global framework. But till then, what to do? First, there are a few steps which we implement from our point of view as a responsible AI practice. What we do is many a times we receive such tasks or such projects where we have to utilize personal information. So what we do is we interact with our clients. We ensure that data gathering practices which they have are ethical. They are not in gray area or black area of personal information. We ensure it, as likely mentioned by Swar and Parth, that OpenAI has this clause within their terms and condition that they'll utilize our data for their own training. So what we do is we implement we have derived a process which is right now in patent. What that process does is it hides the personal information which we share with any of the paid LLMs and still get desired results. And then we fill on personal information over there. Just to give an example, if I want to draft a personal email by OpenAI for so and so company, so what I'll do is I'll share company's URL, but I'll not share all the personal information for any person who I am emailing. I'll just ask that draft an email to Withla that I want to do a collaboration with them. OpenAI will draft an email for me for collaboration. I'll fill in all the required details, like whom to address. This is what I'm looking for. This is my skills, how I can collaborate with you guys. And then I'll share that email from my own hand and from my own device. I won't ask any of the automation software to do it. That is the practice that we ensure personal information is not transmitted. While gathering data or information, implement bias removal techniques. What this particular piece does is it helps us into removing certain aspects. We had this healthcare project back in 2022 where we had to give treatment plans to end customer. If someone comes to this particular service and asked whether they want a patient asked that I need treatment plan, I'm facing cold and fever, prescribe me medicines. So what that AI did is it started formulating a treatment plan that you have to take inhalation, you have to take steam bath, steam inhalation, you have to take medicine for 3 days, twice a day, and so on and so forth. That treatment plan was derived from AI. But what was the crucial piece lacking? That not personal information is to be shared. I'm not sharing patient's name, I'm not sharing their details, and I'm also not sharing any of the crucial information which can let AI know that my patient is this person and they are coming up to ask this information. So earlier it used to do it, and what we faced is black people. AI used to pitch certain medicines to black people only and not to white people. As this was in US, this was the bias we faced. And we came to know that the medicines which black people were prescribed, data which was coming for training to us had this bias into it. So since then, what we did is we sat down with our stakeholders, with project owners. We discuss what are the biases which they face because human tend to do have some bias. We wanted to implement a bias-free environment, but it was not possible for us. So we narrowed it down as much as possible. And that's how we continued this practice. Since then, before starting project, we look at data and we remove bias from it. Selection of algorithms and API also matters into compliance certifications for responsible AI practices. If someone have told me that back in 2023 you use Gemini or Google's algorithms to patch out all the details or to build an LLM for healthcare industry, I would have strictly said no, because Gemini back then was not HIPAA compliant. And if I would have used it, even if it was cheaper, if I have used it, then my client won't have HIPAA compliant certification. And as such, it is my duty to let the person know that within this framework, even if it is cheaper for you to implement, you won't be certified and your personal information or your patient's personal information would be transmitted at this place. But now, if you say that Gemini, do implement Gemini, I would agree with you. They are HIPAA compliant now, and I would have utilized it. As discussed, a few of the use cases which I have. Back in time, we were building a profile recommendation and search system that company posted a job portal or a job post that we are looking for CTO, CEOs. We had to give them from their database itself, AI had to give them relevant job profiles for their end clients. This was B2B portal. And what we did, we built a system where personal information from resume was hidden. Let's say if you are using Naukri.com as of now, some company is looking for CEO, CTOs, then what Naukri will do is they will first pitch profiles which they have in their database. If no one is selected, then that job post will come to you. We did a filtering algorithm. We derived GenAI in such a way that if any profile is shared with recruiter, their personal information, that their education, from where they did their education was written, their name, their number was written. And we saw that non-Ivy League members were hired based on experience similar to Ivy League members. Company did not give priority to IITians, NITians, and they started giving priority to one who are very skilled. Because in India, we do face bias that IITians and NITians are given priority, even though they don't have required experience for the job, just for their degree. And so we take this, we built this algorithm, and we saw that gradually shift started happening. Instead of IITians and NITians or BITS Pilani employees or students, I would say, the one who was deserving for the job was given priority for selection, and they were then screened based on their experience. So this kind of systems, this kind of implementations at the company level will help you or will boost you in delivering cross-country AIs. Implementing these steps at every project will, make your clients, like your project owners, sell their product at global level without needing any such restrictions or any such new information or adaptation to the software. So these are a few of the examples which I have came up with. As time is very limited, I'm concluding this session. Thank you so much, and I'm looking for the questions in the end. Thank you.
Thank you so much, Mr. Akshay, for your insights. Now we are opening up the floor for questions. So you can put down your questions in the Q&A. In the meantime, we have a question for Mr. Swar. What international frameworks can India learn from when drafting AI laws?
That's a very good question. How India should focus, especially in a time where we are one of the biggest data producers. So I believe in terms of data, there are various bylaws, for example, GDPR. We already have our DPDP Act and DPDP rules. So since we already have this kind of regulations, I believe half India needs to understand will be defined by the Indians itself, because the way we behave to bylaws, the way we use the tech is a lot different from other countries. So I believe rather than learning from foreign laws, it will be more important for Indian government to focus on the local people and how they're adapting the technology of AI. That's what I believe.
Thank you so much for that reply. And we have a question. I think this one is for Mr. Parth. How to handle data contracts for clients and vendors?
Yeah, thanks for the question. So, a pretty straight answer for that. Do implement CLM systems in your organizations, or if you are using personally, you can have personal access to take subscriptions of CLM, which is contract lifecycle management. We as a Signet do have CLM in place. You can feel free to reach out to us. We have our own CLM software. It is definitely compliant with all the applicable regulations, which will help to ensure that the data is not uh, compromised. It is not moving out of your system. If it is on premise, it will stay at your premise. If it is even if it is moving out, it would be only through a valid dedicated channel, which is completely regulated. So those CLM systems will help you to have a streamlined process of contract drafting, review, and management, and storing end to end till its end life cycle, till we don't discard the contract, right? Till that. So it will help that.
That was definitely an insightful answer, Mr. Parth. We have another question for Mr. Parth itself. What do you see as the biggest legal challenge companies face when adopting AI? And how is your team preparing to address it?
So the biggest challenge is I had thrown some light on it in my presentation, is that we don't know what new regulation will come up with. We today manage our systems the way we want. There is no blanket regulations to follow. Government may come up with a stricter regulation in a future date. Not right now. It will come up with slowly and slowly. It will keep on increasing the compliance. But yeah, that's again a gray area, a dark area. We don't know what will come out under the head. So that's really playing like in the dark.
That was definitely an insightful answer. We have a question for Mr. Akshay. As someone building AI products, what's your biggest concern around future regulations?
Likely mentioned by Parth and Swar both, if any modifications are done to current framework in some negative manner regarding PRI, regarding implementations of data, regarding storage of data, we might see slash to current features, current data infrastructure, which we already have, and products will be impacted by very huge margin for short duration. We, as an Indian, we are, jugadu, I would say. We will find some way into implementing a workaround for it. But for a duration, we might see that there is a lag in quick deployments, which we already need. We are far behind compared to other countries in foundational models. We don't require foundational models, but having know-how is still lacking in India, and quick adaptation is still lacking. So if negative impact of policy is there, then it will we will be still be behind compared to other countries.
Definitely, that gives a clarity on how regulation and innovation can go hand in hand. We have a question for Mr. Swar. How should regulators balance innovation with privacy and ethical concerns in AI? So you're mute.
Sorry. So we have this framework of international players where most of the AI organizations are following. It's BAT, where B stands for biasness, A stands for accountability, and T stands for transparency. So this is something is very important. It's not a cricket bat, but it is something very much useful when it comes to defining the AI systems. There's another model as well, which is an hourglass model, which focuses on how AI can be implemented in the companies, where in the top level it's the bylaws, in the middle where the hourglass becomes narrow, it's something where the strategy of the company is to be considered, and at the bottom again the broader aspect where the AI systems itself will be implemented based on the strategy and the bylaws. So that's, I think, what should be the approach towards maintaining the BAT.
That's definitely a very effective perspective, stating that innovation and ethics should not be odds. In fact, they have to go hand in hand. We have a question for Mr. Akshay. From your perspective, as both a data scientist and founder, what's most crucial, most critical technical or ethical consideration companies should keep in mind when building or deploying AI systems?
A very broad question, I would say, Saloni. This, as a data scientist, if I have to give an answer, I would say usage of current trend or current technical trend is what I would look for. I'll churn out quick products from it, and I won't care for any data practices which is coming up with. But as a founder, if I have to look at a broader picture, my first strategy, or rather say, product building impact will be on from where I gather data, what is my target audience, and how effective I can keep it safe and as ethical as possible. Data generated by AI or a person has a bias into it, and BAT practice starts at upper management level, as likely mentioned by Swar. So, yes, I would look at that. I'd implement a framework, likely mentioned by Parth that they do have a framework at their end, and I would like to take his assistance into implementing it.
Sure,
I'll do
sure.
that,
Feel
and
free to, yeah.
definitely, Parth. Let's work on it. And
Sure, sure.
from there, I'll take on an approach, cautious approach into gathering all the information, securing it first, and then giving it to AI, following responsible AI practices. Likely, it will take me 1 or 2 months more compared to if I have utilized the data scientist approach, but in longer run, it serves the purpose.
A very well put in answer, Mr. Akshay. We have a question for Mr. Swar. I want to ask Mr. Swar Kansagra that with AI regulation rapidly evolving across different jurisdictions, what should companies prioritize to stay compliant while still remaining agile in their AI developments and deployments? So you're mute again.
Yes, the answer to this is the topic of this webinar itself, navigating the data. It's of course how you define the ownership of data, and of course you understand how the data is being processed, whether the data fiduciaries or the data processors or the data generators are someone who are providing you the solutions, or this is a third party solutions on which this kind of an evolution is happening. So when it comes to multiple jurisdictions, it's as mentioned by Mr. Path, that when the data is being processed, even if it is processed in India, and if it is of an individual, say for an example from Europe, then it will be implicated by the European bylaws. So when you're talking about kind of an AI regulations and developing AI solutions, what I believe is the date or the place of the process also matters. And of course, the ownership of the data, as in who is owning that data, the jurisdictions of that ownership will also matter. So that's what a company need to consider before developing AI solutions, as Mr. Akshay already discussed about this spectacle scenario.
Thank you so much for the answer, Mr. Swar. Considering the time constraints, we have one last question, and this can be addressed by all three of you. And in the age of AI, who should ultimately own the data and the outputs? Users, developers, or platforms? And how do we create a fair ecosystem around it?
I believe we will go with the industry expert first, and then the in-house counsel, and then I will be at the last.
Thank you, Swar. Who owns data currently? I would say organizations at a scale right now. Who should own data in future? I would say yes, rights should be given at an individual level rather than having organizations capture this. We had this Ghibli trend recently, and after a post from Mark himself, this trend picked up pace. Few are very critical on this trend that it is there to collect data, collect information, and as such, our information is there with Mark. And few are very okayish. In India, people are okayish that why should we care? Let's give him our data. Let's allow any application to utilize our information. We are very casual for this. It should not be the case. Information and data should be at an individual level. Down the line, ownership of data and protection should be with the product itself, which we are using. The company who owns that product and product itself. Consent at every level should be asked, and transparency when it comes to sharing should be implemented. But I think that is an euphoria scenario.
Mr. Parth, we would like to know your perspectives as well.
Great perspectives on this by Akshay. I appreciate that. I think Swar will see from where I'm coming. See, my answer depends upon the party that I'm representing. If I'm representing a product developer, I would say that the the data should be owned by the developer. If I'm representing a company which is consuming that product, I would advise that the data should not be with the developer. It should be with the party consuming it. So as a legal person, it will depend. My answer would depend from case to case because law does not specify at the moment at least that who should own. If that is the case, if we leave upon the contracts to decide, then why not to negotiate and be clear it in writing that who will own the product? I mean, own the data.
So, I mean, taking forward to both of your perspectives, I would like to also add one important aspect, as in till now in human evolution, I believe each and every thing was created by humans. So one or the other way, if you go to any kind of solutions, products, or anything, at the end, it is humans who are doing something. So this concept of ownership came from humans, as in if I am doing something, I am owning it. Now, you all must be knowing regarding a Sophia, an AI bot, which was given citizenship in one of the UAE country. Now, when a robot is getting citizenship, now as per law, whether it's a human body or a robot, these bylaws are defined by citizenship. And when someone becomes citizenships, that citizenship is equivalent to individual. Now, if that bot creates something by its own, because ultimately it's an AI bot, then there's a fine line between who should be owning that data. So, to conclude with my remark, I believe AI is something which is going to evolve, and if we let it overcome us, then we may see a scenario where AI is owning its own data. So that's what we need to think on. I think that is something which we should focus on, and that's one even a very famous social media post where there was a quote by a famous expert that we want AI to do our household work, and we do not want our AI to do our brain work. So this is something which we need to understand, as in slowly and gradually we are turning towards where all brain works are being done by AI, which is of course at the end it generates something, it gives a sense of ownership, is something which is done by AI. And the repetitive task or the things which previously AI was supposed to do, that's what at least humans have seen till the evolution today, is what is being done by us. So this is something we need to understand. Who owns the data is something will time will only say, but We need to focus on how that data is being generated. That's what all from my side. Thank you.
We definitely had three unique perspectives from all three of our experts. Definitely something the regulators will be looking upon once we have a AI policy in India. We have another question, and this is for Mr. Swar. As legal advisor and advocate teams begin integrating AI into their own workflows, what key legal or ethical considerations should they keep in mind to ensure responsible and effective use?
So, one of the key aspect of my answer is already covered by Mr. Akshay, as in when he mentioned that he wants to draft an email for a collaboration to with law, he will not focus on any disclosing an in confidential information. For example, the name of the person who is drafting the email. I would go a step further with that. Apart from confidential information, you also focus on being a lawyer, you also focus on the references being generated by AI, which was touched upon by Mr. Parth. So, what is it that you want from AI? As a lawyer, we can use AI for drafting petitions. We can use AI for referring Supreme Court judgments. So, being a law firm, being a lawyer, what we need to focus is we have this verification process, a scrutiny thing where anything which is drafted by AI, just like IT companies, where Parth is there and Mr. Akshay is there, we also as a law firm need to consider this technology as a supporting tool and not the top of this matrix. So whatever we get from that technology, as lawyer or as law firm, we need to verify whatever it is being generated by that particular AI model. So a verification with the support of AI is what we need to do. Thank you.
Definitely, that question was a very important question and it was very well answered by Mr. Swar. We have another question, and I think this can be answered by both Mr. Swar and Mr. Parth. What are the key legal and regulatory challenges you see emerging around data generated by AI systems? And how should companies navigate issues like ownership, accountability, and compliance? So I think we can start with Mr. Parth.
Yeah, so the with respect to what kind of data, I think it depends upon which industry you are operating, which kind of data is being generated. If it is a pharma industry, it is already highly regulated. PHI, which is personal health information, PII, which is personally identify information. There are HIPAA compliances in US. There is GDPR. In India, there would be Data Protection Act. So, and even without this data protection act in India, I think pharma related industry data is already being regulated and it is completely owned by the the patient, right? So, in a similar way, it depends upon the industry, right? If it is related to something which is very general in sense, for example, let's take railways. Now, there is no point of regulating the data generated from railways. If I book a ticket from point A to point B, how does that is related to my confidentiality? It was just a travel, unless it was something to be meant confidential. For example, let's consider army or defense, right? Now that is again, there are plenty of private companies working in defense, though India has not privatized the defense sector, but there are companies working in the defense sector, private companies. Again, the data, if they use any AI product, or they have implemented AI, there may be thousands of GBs of data, which is very crucial for a company, for a country, right? So that again should be treated separately. So I believe each and every industry should have separate norms for data regulation. It cannot be one single norm for all the data related things. Now as we speak about AI Act, government should come up with a schedule, some sort of in the act whenever they come, specifying the type of industries where regulation. So if now again, nice question, because so Swar would recollect to this and agree to this. In AI Act in UK, they have divided into three the sectors, which is regulated, restricted, and less regulated. Now, restricted are the areas where there is a complete ban on use of AI, regulated are the areas where the companies can do AI, implement AI, but with some sort of regulation of the body. And less regulated are literally open. They are free. Develop whatever you want using AI. So some sort of that regulation should also be implemented where the ownership would be defined accordingly. If it is regulated, then it should be, regulated. If it is open and free, data can be owned by the person who is generating, not I mean the company, the developers. So in that way, it can vary from case to case.
The biggest challenge that we face today is the black box thing, where in terms of data processing, I believe we have this frameworks, we have various regulators framing acts. For example, EUA Act, or if we talk about data, we have DPDP Act or GDPR or CCPA with respect to US. But when it comes to the processing of data, one of the biggest challenge that we are facing today is we cannot trace the process of that generation of data. All the acts and all the rules and regulations, if you carefully see, they are focusing on disclaimers before using that data. We do not have anything for a case scenario where the data is already been used by the system and how to process that data. Even if that AI system is processing the data, we do not have any technologies or frameworks which talks about how can we verify the statements made by such companies, as in how they are processing. So this is one of the challenges that as an industry we are facing. That is what I believe is something which we need to consider.
I think the generation of data by AI systems definitely comes with a lot of challenges, and hopefully, we'll be regulating all of this through the future policies. We have a question for Mr. Akshay. As a data scientist and founder of an AI company, do you involve legal experts during the development of your AI products? If so, what key legal aspects do you focus to ensure your solutions are compliant and risk aware from the start?
Yes, we do have legal advice being taken at every step of development, not while having actual development, I would say, while before development starts and after development is done. We follow a step-by-step process where gathering all the information for a product and all the data and legal laws is to be taken into account. That's when steps are implemented that how we will work around our way with all the international market. As every product we have will go eventually to those countries, we will have to incorporate every law, and that's how we have derived a particular set of method after a number of permutations, that this method is okay with Europe, this method is okay with US, and as such we implement them along with legal advisors. Mainly considering all the tools, new and upcoming tools, we have to come back to legal advisors again, give them the tools that yes, this is the tool we are willing to implement, have a look at it, go through all the legal terminologies and terms and conditions, and let us know if it serves the purpose or it is to be utilized for such and such certifications. So that's how we bridge the gap. I do that with the legal and industry as such. So yeah, that's the answer.
That was a very well put up answer, Mr. Akshay. We have a panel question again, addressed to all three of you. As AI becomes more deeply integrated into business operations, how can legal, technical, and policy teams collaborate effectively to ensure AI systems are compliant, ethical, and aligned with both innovation goals and regulatory expectations? Definitely a very interesting question. I think we can start with the industry expert, Mr. Akshay.
I would like Swar to take lead on this first, and then I'll share my inputs.
Sure,
Over to
thank you.
you.
So when it comes to teamwork, I believe the perspective of the interpretation of bylaws is very much important. That's what as law firm we do. We represent various clients in various sectors. So we interpret bylaws as in, so that's what we can help, and we collaborate as in interpreting the compliance, interpreting the bylaws that an IT company needs to follow. And then I think we'll move to Parth to focus as in what should be the next step.
Thanks, sir. I agree. We should always be in aligned with whatever legal developments are there. Not necessarily in case of notifications or proper acts, but even the discussions or regular updates or some sort of panel discussions should be helpful, and we should try to gauge what government is up to. And if we develop our products in that manner, it is very much likely that we won't be off track, or our investments won't be getting affected to a great extent. So yes, we should be developing the products in that line, and try to make it compliant with each and every step, not only when the product is fully developed. This will help to make changes and adapt to the changes effectively. So for example, if there is a major change when 90% of the development is done, then again development and making some sort of adjustments will be little difficult.
I'd like to add just one point to the speakers who have mentioned the answer.
Yeah.
AI process is an iterative process, I would say. Just a moment. About collaboration, I would say AI process is an iterative job. It constantly adapts, it constantly learns from what we have done. There are upcoming tools. Every now and then, new tool is coming up. Every week, we see that just last 2 weeks, we came up with MCP server who are in trending. Right now, yesterday or day before that, Google came up with agent-to-agent protocol. That is again a new way where agents individually can collaborate with each other. So innovation is coming up at a rapid pace. Members here have to keep on reading new innovations and their legal terminologies, while few people like me have to get their hands muddy and dip dive into actual implementations. So what we do is we talk to all these guys. We have this sessions where we take on inputs from Swar, Path, me, Saloni, everyone. We hear, we collaborate, we discuss what I have done, what they have learned, and then take things forward. Innovation will keep on happening. Legal laws will be modified according to countries' policies. Rivalries will be there, like we had with New Zealand. We started discussing after Trump's tariff. We again have this trade agreement with them where AI is also part of it. We have UK based agreement where technological transfer is also there in terms of defense, in terms of AI. So it is also being negotiated. So every now and then it will keep on happening. You just have to anticipate it. You have to build in a certain framework where any inputs or exception from the product does not impact much of your needs. You build your product in a decoupled manner according to the legal law within the countries where your target is, and that's it. That's how you build a successful product.
Thank you so much, Mr. Akshay. I think it is very clear that effective collaboration between various teams is the key of navigating this complex era of AI. And with that, I think we are coming to the end of today's session. It was definitely an eye-opening webinar, and I want to extend my heartfelt thanks to our speakers, Mr. Swar Kansagra, Mr. Parth Chhatrala, and Mr. Akshay, for sharing such profound insights and practical frameworks around one of the most urgent legal topics of our time. I would also like to extend my big thanks to our supporters, Signet, Indian Technology News, and WICCI Karnataka Technology Empowerment Council, and WICCI National Council for Artificial Intelligence for their valuable contributions to today's event. So before we wrap up, here's a quick heads up. Our next exciting session is just around the corner, and on May 17th, we'll be hosting our next webinar on data centers and data disputes, navigating legal complexities in digital infrastructure and data management. So the registration link for the same will be available in the Q&A box, and more details will be shared through our WhatsApp group. So stay connected, and the link to the WhatsApp group will also be available on the Q&A box. And remember, today's session has been recorded and will be shared shortly in our WhatsApp group. So stay tuned for the same. Once again, thank you all for joining us and being part of this important conversation. We look forward to seeing all of you in our upcoming session, and have a wonderful evening ahead. Thank you so much.
Thank you.
Thank you.
Thank you.
Thanks. Bye bye.